Assalamualaikum, Doctor. My name is Fatina Bila binti Muhammad Zaidin, metric number 295266. I will start with the first question, which is I will answer for the term and condition agreed in the guarantee document between Bank Bangunan Malaysia Berhad and the defendant, which is Ibu Kota Realty Sdn Berhad and Loh Chia Hong. For the first term, which is liability as principal debtor. So the agreement established that the defendant would bear direct responsibility as principal debtor for the debt owed, rather than merely acting as secondary guarantors. This agreement allowed the bank to pursue the defendant directly for the outstanding amount without the need to exhaust other avenues of resource, such as pursuing the borrowers or other form of collateral first. So for the second one is conclusive evidence. So for this term is the guarantee document specified that any statement of an account or certificate of indebtedness issued by the bank regarding the borrower's liabilities would be considered final or binding, except in cases where a clear factual error was evident. Despite the defendant disputing the amount claimed by the bank, they failed to prove evidence to amount substantiable their challenge, thereby upholding the validity and conclusiveness of bank document that amount. So for the third one is waiver of right. So for this term of guarantee, with the defendant's right to demand that the bank first explore alternative avenues for debt recovery before enforcing the guarantees. These provisions streamline the debt recovery process, allowing the bank to promptly proceed with enforcing the guarantees without delay or the necessity of pursuing other form of security or legal action against the borrower. Okay, let's continue with the fourth term, which is protection from amendment. The guarantee documents safeguard the defender's liability from amendment, variations, or extensions to the loan agreement or interest rate. This means that any changes made by the bank to the effective cost of fund rate, for instance, were within the bank's purview without requiring explicit consents from the defendant, ensuring the continuity of their obligation. So for the last term is additional securities. So for this term, the guarantee were explicitly framed as additional layer of security, independent of other form of collateral held by bank. This provision fortified the bank's position in debt recovery by providing supplementary protection and ensuring a more efficient and direct process for recovering the outstanding debt without being contingent on the status or realization of other securities.
Assalamualaikum, my name is Sharifah Nuwadina binti Sabdalin, my matrix number 26507. So today I will present about the what were issue raised by the defendant. So basically this case has two party involved, which is the plaintiff Bank Pembangunan Malaysia and defendant Kota Realty and Loh Ching Hing. So what were the issue raised by the defendant? So first issue is failure to demonstrate calculation interest. So defendant said that the bank didn't explain how they calculate the amount they own. So the notice that was sent on March and May 2017 didn't show how the number or interest rate ECOF will work out. So this has led to claim being lack of transparency and unfairly high amounts. Then, failure to notify the rate change. The defendant claimed that the bank didn't inform them when the interest rate ECOF changed. So the defendant feel like this was unfair since they were given a chance to agree to the change. So the next issue was the liability apportionment. So defendant argued that the bank should have used other assets or guarantees as a security first to recover the money instead of demanding it all from them. Then the next issue was the incomplete disposal of security. So the bank had appointed a receiver and manager to manage the asset. The defendant felt that lawsuit was premature because the asset sale process was not finished yet. So, but what the court said is the notice was sent to the borrower, not the defendant. So, and it didn't need to include all the details that the defendant wanted. So then the defendant also stayed silent when the notice were issued, so they could not raise this objection later. So the court found that no strong reason to continue the case. So in conclusion, the court ruled in favor of the bank and the defendant argument were dismissed and the summary judgment was granted to the plaintiff.
Assalamualaikum Doktor, my name is Muhammad Taufiq Ilmi, my matric number is 301419 and I will explain the answer for the question 3. Okay, the question 3 you are asking about does the plaintiff have the right to enforce the guarantee provided by defendants due to the loan facility being in default? So the answer is yes. The plaintiff has the right to enforce the guarantee provided by the defendants due to the loan facility being in default. There are some reasons why the answer is yes. For the first one is because the principal debtor liability. In these terms, the guarantees executed by the defendants classify them as principal debtors, meaning in this context, they are fully responsible for the debt, not just as the guarantees. This established as a direct obligation to pay the outstanding amounts regardless of the borrower's status. For the point number 2 is the independence from borrower's obligation. The terms of the guarantee specify that defendants' liabilities are not affected by any changes to the loans agreement or the borrower's obligation. This includes any extensions, renewal, or alteration, ensuring that the plaintiff can enforce the guarantee if the borrowee in default. Okay, the third reason why the plaintiff has the right to enforce the guarantees is because no requirement to exhaust the other remedies. The plaintiff is not obligated to pursue other securities or remedies before enforcing the guarantees. The guarantees are considered as additional securities that allows the plaintiff to directly call upon them to recover the outstanding sums without needing to first realize the other assets. The last one is about the court's conclusion. The courts affirm that the guarantees provided by defendants are enforceable and that plaintiff can proceed with legal action to recover the amounts owed under the loan facilities as the issues raised by the defendants were considered as unquestionable.
To answer the question of number 4 is that in my opinion, the plaintiff and defendant need to have the nature of relationship. So the guarantor assumes secondary liability for loans, meaning they agree to repay debts if the primary borrower defaults. So clear communication from lenders to both borrowers and guarantors about any changes is essential. So the second one, we have the defendant's argument. So the defendants claim they were not informed of changes in the effective cost of fund rate, which they argue affected their concern and liability under the guarantee. The third one, we have court's finding. So the evidence showed that the lender had notified the borrower of the rate change prior to the defendant raising their concern. So the court notes that because the loan facilities were terminated before these concerns were voiced, further negotiation were unnecessary. And then they argue about the estoppel and timely objection. So the defendant failed to timely contest notices of demand and termination, suggesting they might be stopped from challenging the lender's claims. So estoppel prevents party from contradicting established truth if another party has relied on those truths. Then they are arguing about the burden of proof. So the defendant did not provide sufficient evidence to counter the lender's account statement regarding outstanding balance, relying only on denial, which was deemed inadequate by the court. And then legal implication, which is the ruling underscores the importance of adhering to contractual agreements and fulfilling obligations as outlined in loan documents. It reflects a judicial trend favoring lenders to the right to recover debts efficiently while holding guarantors accountable for their commitments. So in conclusion, while the defendants may feel wronged by a lack of communication regarding loan changes, their obligation as guarantors and their inaction significantly weaken their position. This case highlights the